Welcome you all to the lecture series on corporate law. The present lecture would be dealing on the important aspects of the Chapter 16 of the Companies Act 2013, deals on the aspects of prevention of oppression and mismanagement. To provide the brief introduction about the subject is that in the management of companies, we always find the conflict between haves and have-nots in the logic of the people who have the majority and people who are in the minority. The question comes whenever there is a minority shareholders, because minority shareholders are bound to happen, whether minority shareholders are given any rights to protect their own interest and also to protect the interest of the company, because there are circumstances where companies acts contrary to the basic objects of the company. The majority of the members in the management may try to bulldoze or may try to implement or interpret and implement the aspects of the their views, their opinions, and the aspects and the opinions taken by the majority, if are in the best interest of the company, then it's fine. But if the opinion taken by the majority of the shareholders are not in the interest of the company, then what will happen? Whether the majority members can take the decisions always with an interest to defraud the company or with an interest to suppress or to oppress the one of the class of the company, that is minority shareholders. Therefore, under the particular Chapter 16 of the Companies Act 2013 deals with regard to the how to prevent the oppression and how to prevent the mismanagement. So I will try to briefly explain what are the various legal concepts with regard to the oppression mismanagement, and secondly, how far these legal concepts or the principles have been applied before the court of law. Now, Section 244 of the Companies Act speaks about or the deals about right under 241 who can apply to the tribunal. So let us see what the 244 of the Companies Act says. According to the Section 244 of the Companies Act, the following members of the company have a right under 241. Now let us see what is there in the 241. Now Section 241 speaks application to tribunal, right? Application to a tribunal for relief in cases of oppression. And the very crux of the oppression has not defined under the Companies Act, but there are a lot of cases and instances where the tribunal take consideration that these aspects will fall under the meaning of the oppressions. Let us see the provisions. Let us see the language of the Companies Act, how it deals. Then we will move with regard to the case laws. According to the Section 241, any member of the company who complains. Now, who is a member of company? Under Section 2, Clause 55 of the Companies Act, right, under the same legislations, the member has been defined Because you may say that why the member has been used. Because the member is the one whose names are entered into the register of the shareholders and also subscribers of the MOA and also the beneficial owner whose names are entered with the depository. So there are three classes of the people who comes the meaning of the member. Any member in the sense you can understand, even a shareholder of a company can make a complaint to the tribunal when the affairs of the company have been or are being conducted in a manner prejudicial to public interest, manner of the prejudicial, or oppressive to him or any other members or members. So this is very important, right? If there is a Mr. A is a member, if A has come to know that some activities are oppressive in the nature or prejudicial to the company or even to the other members, right? Even to the other members, then A has a right to file the complaint under section 244 and section 241. Kindly remember the section 241 to 244 is also the procedural clause, right? You can draft the petition, right? You can draft the petition under section 241 to 244 and file the petition before a tribunal for the activities conducted by the majority shareholders. By majority shareholders, you can file it for a tribunal. So under 241 clause number 1, it says any member who complains that the affairs of the company have been or being conducted in a manner prejudicial to public interest or in a manner or oppressive to him or any other manner or members or in any manner prejudicial to the interest of companies. This is one of the gray areas of company law, right? The question will come, what do you mean by interest of company? Everybody will say the companies are incorporated to get the profits. There can be a companies even for the losses. We have the companies who created to eliminate some of the competitors in the business, right? They eliminate other people and therefore they want to expand their business. Interest of the company, the examples which we can give is that interest of the company means achieving the objects of company, which is already given under the MOA. Kindly remember, because any person will tell object of the company or interest of company means the interest of the company is nothing but of the profits. But the answer will not always be right. The best interest of the company is to achieve the objects which are laid down in the what we can say MOA, in the MOA particularly object clause. So under section 241, any member may file a complaint before a tribunal if the acts are prejudicial to public interest or if the acts are prejudicial or oppressive to him or any other members of the other members, and also if the activity is against to the interest of the company. That is the subclause number 1A. Subclause number 1B is the one of the biggest clause. What it says, the material change not being the change brought about by or in the interest of any creditors or the debenture holders or class of the shareholders has taken place in the management or control of the company, whether by alteration in the board of directors or manager or ownership of the companies of the shares. If it had no share capital in its membership or any other member by reason of such change. So this requires huge explanations, but I will try to explain a very brief one. If any changes which are brought by the company, which are against to the interest of the creditors or the debenture holders, the members can have a right. And here also it provides any class of members may apply the tribunal, provided that they have the under section 244 the remedy is provided. Now the another question will come, right? The other question will come under 241 when you say any member, whether is there any number is given. That in the number means, for example, if a Mr. A is having one share rupees 10, right, in the company called Reliance group of companies. Mr. A is having one share which is worth of 10 rupees or maybe worth of 100 rupees. Whether he can file a petition as a minority class. Otherwise, what will happen? Then they have to define who is a minority class, in which the minority has been discussed under section 244. So because one person having the one share cannot file. He cannot file. Why he cannot file, we will see. That's where it says right to apply. You don't get confused. 241 tells about the member. Now 244 talks about right to apply under section 241. That's what commencement of the class I brought, section 244. The following members of the company shall have a right under section 241. Then who are these members? Not less than 100 members, not less than 1/10 of the, right, 1/10 of the total member of his members, or 1/10 of the share capital, paid up share capital, right? That means if anybody wants to file a complaint, if the company is having the share capital, right, in the case of the company having a share capital not less than 100 members, suddenly you will have a doubt. Sir, if there is a company only having 7 members, right, that's what we read in company law. We have a company having only 7 members. Now this logic will not work out. If there is a company which is having only 7 members, the logic is 1/10 of paid up share capital, otherwise called the 1/10 of the voting rights. So the logic they brought it called, if the members are more, then you have the 100 members, and if not the members are only 7, then you have the 1/10 of capital. In a simple understanding, they brought it called, if there is 100, then they brought it called 190 into 10%. This 90 is always about the minorities. If you have the 100 shares, then you have the 90 one side, 10 one side, where you put equally. So try to remember when you talk about the members. So the members means our 100 members are 1/10 of the members who have the capitals. And subclass number B, right? This is what we talk about the paid up capital. 241 class 1 subclass number B. In case of a company not having the share capital, if it's a guarantee company, not less than 1/5 of total number of its members. This is a guarantee companies, right? In the case of guarantee companies, it is 1/5. Now to put it very clear, 100 members, 1/10, then 1/5. So where we can understand very easily, these people comes under the class of the minority or the right to file case. So then we can find about the logic which is provided under the company law. The minority means who is the minority, then who can file the case laws. Provided the tribunal may an application on its behalf may waive all or any other requirement clauses on A and B to enable the members to file up to 241. This is again comes a proviso is given a tribunal, right? A proviso is given under 241, 244. The wide powers are given to a tribunal in the case where the shares or where the activities are such that the prejudicial to the interest of the company and prejudicial to the interest of the shareholders, creditors, or the company is doing some activities which are not interest of the company. So therefore, these always have a right to file a petition under the 244. The explanation of the 244 is that for the purposes of this subsection, where any share or the shares are held by two or more persons jointly, it can be counted as one. This is the explanation. Joint shareholding is counted as the one. And subclause number 2, where any member of company entitled to make an application under subsection 1, any one more of them obtained consent in writing of the rest may make an application. It is very simple. One person can take the consent of 99 persons. Total it becomes 100 members. Then this one can file a petition. This is where this clause is coming. Maybe to make very simple, I will erase this. I will just to explain this particular subclause, which we are talking here is that if there is Mr. A and he can file a petition by taking the consent of another 99 members. So this is where this provision try to explains to you in order to understand the concept of consent on behalf of others. So under section 244, one person or the 1/10 of the persons who have the shareholdings 1/5 for guarantee companies, then they can file the petition under 244. 241 we have already studied, and some of the areas which we require to understand is about the public interest and the prejudicial and oppressive manner, because oppressive as well as the harsh, the definitions has to be taken from the dictionary meaning. The definitions has to be taken from the case to the case wise, because in a given particular situations we can say that this particular act is very much harsh. Then under 241 subclause number 2, if it is in the opinion of the central government that the affairs of the company are conducted in a manner to the prejudicial to public interest, it will apply to the tribunal. So that means central government can also make an application to the tribunal when the acts are prejudicial to public interest. So this is made very clear. They can make applications. Now let us see the powers of the tribunals. Once an application is made by one of the member having recovered this majority, and what are the power that the tribunal is having? So under 244, the tribunal is having certain powers. These powers are, number 1, if they are oppressive in the manner or public interest and the company's affairs are being conducted, it can pass some of the orders. One of the order is that winding up of the companies. That means close your company, because the activities are in such a nature, therefore you cannot continue the company's business. But if the facts otherwise justify the making of the winding up order on the ground, just and equitable ground, it should also go for the wound up. So one of the ground where the minorities are given a right, if the activities of the company are conducted in the nature of oppressive, if the tribunal finds the activities are in oppressive nature, they can pass an order to wind up the companies. So therefore, under section 241, the minority have the power to bring one of the remedy or to file a case for one of the remedy for the purposes of the oppression as well as the mismanagement. That is what is called about the one of the remedy. Then other remedies, it can without prejudice to the generality, without prejudice to the generality of the powers under subsection 1, an order of that subsection may provide for regulation of the conduct of affair, purchase of shares or interest of any members of the company by other members. In the case of the purchase of the shares by other company, the consequent reduction of the capital, restrictions on transfers and allotment of the shares, termination, setting and modification of any agreement, then setting or transfer and delivery of the goods, removal of the managing director, manager of a company, recovery of the undue dues, and also appointment of the number of persons, directors who may report to the tribunal directors. We call as the 242 directors. I will explain one by one. This makes us to understand very easily reading of the provisions. When you see the remedies, one of the remedies is to wind up, other remedy is regulation of the affairs of the company, and other remedies are to protect the interest of the shareholders, termination of any agreements, and also the any issues relating to transfer of the goods, removal of the managing directors, and in the case if there is a requirement that the company has to be controlled or managed, or the affairs of the company are need to be controlled and managed by the tribunal, then tribunal can appoint a director under 242 directors, and they try to control the company by managing the affairs of the company. They will report to the tribunal as well as they will also report to the registrar about the aspects of the company has to be conducted. That means at any point of time, right, at any point of time, if the activities of the company are considered to be oppressive in the nature, it may be oppression by the directors, it may be activities by the agreements on the transfer of the shares, as well as other modes. So always there is a remedy which is provided to the minorities as well as to make about their what we call about the various remedies under the company law. For example, if minorities are not paid dividends, if a company declare a dividend and not paid a dividend, they are suppressing them, they can also file. As well as if the company declare a dividend and they have to pay to the shareholders and they are not paying to the shareholders, and also they are not returning the money to the investor education fund, then that's what they say is identification of repayment to the identifiable victims. So the company law provides a pelotra or a bundle of rights and bundle of remedies, right? A box of rights and remedies are provided under section 241 to 244, where the people can file a case who comes under the category of the minority, and they look for the remedies under the Companies Act. Then again the tribunal powers, I don't want to read lengthy provisions. Let me take one of the oldest case, very famous case with regard to the oppression mismanagement. This is also called as majority rule. It's a very interesting case. Though judgment is not in favor, the dissenting opinion is part of the law. Majority rule versus what is called minority protection. Majority rule versus minority protection. One of the oldest case of the UK judgments. Let us see the facts in very brief. Richard Foss and Edward Starkey, that's called Foss. Foss were the two minority shareholders in the Victoria Park Company, which was set up in September 1835 to buy 180 acres of land near the Manchester in order to transform it into a park known as Victoria Park. Subsequently, in 1837, an act was passed by the Parliament through which the company was incorporated for the purpose of laying out and maintaining the ornamental park within the township of Rusholme, Charlton upon Medlock and Moses side in the county of Lancashire. According to them, the property was misappropriated and wasted, and also various mortgages given improperly over the property of company. The allegation is this one. According to the Foss, the complaint is that property was misappropriated and wasted, and also various mortgages were given improperly over the property of the company. Both the shareholders decided to take legal action on behalf of themselves and also other shareholders or properties of the company, and therefore filed a claim against the 5 directors, including Harbottle, Henry Bourne, John Westhead, Richard. And the case who became later, they become the bankrupts. Mr. Foss filed a case against Harbottle where they misused the properties. Their claim was based on the following ground. The first ground was that fraudulent transactions through which the assets of the company were misappropriated. Second ground was related with the insufficiency of qualified directors, right? Insufficiency of qualified directors in the company who can actually make up the board. Third ground was that they had no clerk or office. Due to these circumstances, the shareholders had no power by which they would take property from the hands of the directors, and therefore had to commence legal proceedings against them. It's a 7 shareholders where the 5 are majority or 2 are not allowed to do any activity. So the grounds are that fraudulent transactions, insufficiency of qualified directors. These are the grounds brought by the Foss. In this case, Justice William Wigram VC dismissed the claim of shareholders. That means he rejected the claim and held that an action, individual shareholder or an outsider of the company cannot take any legal action against the wrong done to the corporation, as both company and its shareholders are considered as separate legal entities. It is also mentioned Section 21 Clause 1 Subclause A of the Companies Act that a company may sue and be sued in its own name, and a member may not take legal action on behalf of the companies. And if a company has a right against the party under the contract, then it is for the company to sue it. This is what we know well principles. The reason that shareholders cannot sue is that company is the one who has actually suffered injuries and not its members. So it is on the company to sue or legal action against those members who have misappropriated the property. So kindly listen to the logic, very interesting. Here the judge says the act which was committed, the wrong is not disputed. The dispute is that who can bring the case? Who can bring the case? That is, a company can bring a case because company is the separate legal personalities. Now let us see what happened followed by the case. He followed the judgments passed in order in older cases on the unincorporated companies and insisted the minorities should show how they have exhausted all the possibilities of redressal within the internal forum, as he has stated that the courts will not intervene in those cases where majority of shareholders can ratify the irregular conducts. But this rule was considered as unfavorable for minorities because it barred them from making any legal action. Whenever the alleged misconduct was in law, whenever the alleged misconduct was in law capable of ratifications. Therefore, in effect, two principles were established by the court. First principle is that proper plaintiff rule. This is called proper plaintiff rule. That means who has a right to file a case, which was laid down. If any wrong done to the company, then the company suffers any loss due to the fraudulent or negligent acts of directors or any other outsider, then such situation only the company can sue the directors or outside to enforce its rights. And the other point is that principle of separate legal entity is already well established principles we don't want to discuss. And the separate legal personality means a company is separate from the individuals, therefore the case has to be brought by the company, not by the individuals as such. The only reason is that why only a company can bring a legal action or institute legal proceedings, not any member, in order to recover the losses that has been suffered by the company. A member of the company can take a legal action on its behalf against the wrongdoer if he is authorized to do so by the board of directors or by order resolution passed in general meeting. The second rule is that majority principles. Majority principle is that which laid down if the alleged wrong can be confirmed and ratified by a simple majority of the members in the general meeting, then in those cases the court will not interfere. This is what we call majority rule versus minority protection. Because Foss versus Harbottle is called as majority rule versus minority protection. If majority is able to ratify their wrongful acts, then the court will not interfere. However, the application of the strict principles appeared to be very harsh and unjust for the minority and unjust for the minority shareholders, as although a substantive right have been provided to them, still they were barred from the obtaining justice under the rule, have to submit to the wrongs done by the majority, as they were ones who controlled the company, and minority members have no say due to their small strength. Therefore, in order to mitigate this harshness, 4 exceptions are given. Right? Let us see the 4 exceptions. Majority rule versus minority. 4 exceptions are given where minority have given a right and minority have been protected. The first act is that when the acts are ultra vires and illegal. Second exception is that where the acts are done or section required violation required by the AOA, contrary to the AOA. Third exception is that invasion of the complaints and the individual rights of the company. Last exception is that where a situation fraud on the minority shareholders are committed by the majority who themselves are the control of the company, right? If the majority commits the fraud and minority shareholders, then minority have the right to file a case against the majority. The purpose of reading of the Foss versus Harbottle rule, the Foss versus Harbottle, is that though the majority have given the right, majority protection is given, but the majority protection will not be available to them always if it is contrary to the, or if it comes under the exceptions of these principles. If it falls under these 4 exceptions. What are the 4 exceptions? One is ultra vires, against 2 articles of association, and also alleged acts are the violation of individual rights and the fraud committed by the majority. So these 4 exceptions are now part of the right given to the minority shareholders. So this is where the Foss versus Harbottle brought about the very elaborate principles to understand, to interpret. Otherwise, we are reading a judgment which was delivered 200 years back. The logic of 200 years back is that if the acts are in such a nature where they bring a principle called violations of principles, like for example fraud, if any act which comes in the nature of the fraud, then you have a right. So therefore try to understand about the exceptions which was given under the majority rule falls under about the minority. That's called about the minority rule and majority protection. So minorities are protected under exceptional rules, majority also protected under the rules of the corporate laws. This is the rule versus in the corporate law cases. There are other cases like the elder versus elder. Then we have the Santi Bhushan Jain versus SP Jain versus Kalinga Tubes one. These cases, I will try to take one more lecture for the discussion on the some of the case laws, because we have another case law also, a needle industries case. So this lecture I am just trying to explain 241, 242, then followed by we have the 242 remedies. So to briefly conclude, 241, 242 and 244, and also the discussion of Foss versus Harbottle rule. So this is briefly I try to explain. Therefore you will have the basic understanding of the oppression mismanagement. Then in further lectures I will be talking about the cases. I will also talk one of the new concept called on class action suits, because class action suit also comes as the new developing principles of corporate law jurisprudence. In the jurisprudence of corporate law, lot of law has been developed, lot of principles have been incorporated, that we will discuss in the next class. So thank you very much patiently listening. So kindly write your comments if you have anything in the comment box. So therefore I can update myself, I can come down to the levels to the students if you are unable to follow. So we will see in another lecture. Thank you and take care. Bye.